Good afternoon, ladies and gentlemen. The Associated Student Speakers Program is very proud and honored to welcome today Mr. A.L. Wirin, who for over 30 years has been Chief Counsel of the American Civil Liberties Union in Southern California. Mr. Wirin, who has presented more cases before the Supreme Court than any other non-governmental attorney, has had such a diverse group of clients as longshoreman Harry Bridges, convicted rapist Carol Chessman, and the Los Angeles Times. He has argued many of the Japanese evacuation cases and was instrumental in having the Proposition 14 decision declared unconstitutional by both the California State Supreme Courts and the United States Supreme Court. His present cases involve challenges to the constitutionality of the state loyalty oath and to the death penalty. Recently, when a Los Angeles Superior Court judge upheld the constitutionality of the death penalty, Mr. Wirin, I am told, allegedly remarked, "We don't always win, but we never lose." With this kind of philosophy in mind, he plans to bring the case before the California State Supreme Court sometime this spring. There will be a question and answer period following Mr. Wirin's presentation. Now, speaking on a topic which of late in particular has become relevant to us all, the Bill of Rights on the campus, Mr. A.L. Wirin.
Thank you very much. First, a comment, or not a correction, but a comment with respect to the introduction of me. The chairman said that I have argued more cases in the Supreme Court than any other lawyer, not in government service, and I must tell you that that is largely legend. The fact, simple and clear and ugly fact, is that I have lost more cases in the Supreme Court than any other lawyer. And also I ought to say this with respect to the subject which I have selected, or which has been assigned to me, namely the Bill of Rights on the campus. It may very well be that I will be deviating substantially from that subject. Indeed, some of my friends who've had the duty of hearing me more than once have said that every time I speak on a different subject, but I always say the same thing. And that reminds me of an incident when I was at Harvard. And this is some decades ago, perhaps half a century ago. You can see you can visualize where you were then. You weren't even an idea, let alone something else. In any event, in the 20s at Harvard, the professor of Semitics gave Semitics 2.5, which got to be known as a cinch course, and all the members of the football squad took that course. It was understood that no one needed to attend any of the lectures, but everyone was required to take the final examination. But the professor, being a genial and friendly and amiable professor, as some professors, I was going to say a few, but some professors are wont to be, decided for years to help the members of the football squad. After all, what's more important to Harvard than a football squad? And every year he gave an examination in which the questions were identical, so that a student didn't have to do too much work to know how to answer the questions. And the second question for the last half decade had been, name the kings of Israel in their order. This year, this professor, not being above a little pictiousness, decided to change number 2. And he put the question as, who was Moses and where was he born? Whereupon, when the captain of the football squad reached question number 2, he scratched his head and said, "I do not know who was Moses, nor do I know where he was born. But the kings of Israel in their order are," and so I will talk about the Bill of Rights on the campus but probably say some other things also, as is my wont in answering question number 2. I suppose I cannot be coming here and leaving here without saying something about Tao. And that's not a Taoist Tao, it's a different kind of Tao. And the problems in connection with the Bill of Rights and rights stemming from the Bill of Rights in connection with Tao. I noticed, for instance, that the CIA is no longer on the campus. It has folded its tent. I think the familiar expression is, he folded his tent and silently stole away. But I don't know that that has any relationship to the CIA. In any event, I see that the Dow Chemical Company is sticking to its guns. Or, I suppose to be more accurate, I should say sticking to its napalm. But of course, the matter of the Dow Chemical Company, the activities of some of the students on this campus in connection with that, and correlated problems, not I suppose, but of course it's clear. It involves the whole and large question of the right of protest on the one hand, and the right of academic freedom and the limits upon both of these rights on the other hand. I would suppose, and of course I'm expressing essentially my own views, occasionally I shall be stating the views of the American Civil Liberties Union, but let us say that I'm expressing my own views. I would suppose that initially I will say, and because I believe it, that certainly there can be no academic freedom unless students have, as a matter of right, the right to participate in critical decisions involving their well-being, involving their status, and involving their rights on a campus. To me, that would mean more than merely talking to a chancellor. It would mean more than merely expressing one's point of view through a referendum, though I think that kind of procedure is exemplary. To me, it suggests that ultimate decisions affecting the welfare of students should not be ultimately made without not only the students being heard, which is just a threshold of the exercise of rights, but without the students having some critical and central and dynamic role of participation. I say that not because I am a student, for of course I'm a little too old for that, though I try to be a student of rights and of the rights of human beings. But I say it also because of a personal experience I had close to a decade ago when I went to China. I was a lawyer in a case, and without getting into the case at all, because I was a lawyer in the case and because evidence in communist China was necessary to the case, the judge in San Francisco, federal judge, ordered that I be permitted by the State Department to go to China. And so I was the first American to go to China on a valid passport. As a matter of fact, I was the first American to go to China, not only on a valid passport, but with all expenses paid by the United States government. Because the man I represented was poor, and happily a poor man, when he is confronted with a criminal charge, in some circumstances can have the expenses of his case do you still, but I'm back on, though I don't, I'm not a follower of Timothy Leary. Turns off and on and out. Though I want to say something about Timothy Leary later, and if I don't say it, ask me about it at 1 o'clock or so. Well, I was talking about China, though, and all I want to say about China at this time or at all is that I saw in China, having been there 2.5 months, greater participation in the franchise than in any other state in the world. That is to say, more Chinese persons personally vote in an election in China than anywhere else. And therefore, here is a nation about in practice. This turning on and off is faster than even Timothy Leary recommends. But does my voice fade now and then? But it's not due to my voice. It's due to modern age of electronics. Completely unreliable machines are. In any event, while many persons, women for the first time in China voted, over 18 years of age can vote in China, not in the United States. But I assume the votes are counted. There's no suggestion that no one counts the votes. But they don't count for anything because the administration of the government goes on without any relationship to how many votes, and the only one can vote for are someone who has been designated by the local communist committee. And so what I'm saying is, whatever limited experience I had in an iron country, in this iron curtain country, in this instance, a bamboo curtain country as it is called, leads me to strongly believe that meaningful freedom means meaningful and active participation. So that the right of protest, which I think is the most fundamental, the most necessary, and the most precious of rights in a free society, in order to be meaningful, must be accompanied at a point or at a time when the right of protest is counted in some way in the making of ultimate decisions. But let me then move on to the problem of the right of protest, on the campus, off the campus. The nature of the right, the extent of the right, and the limitations, if any, on that right. Now, I suppose it will come as no surprise to those of you who are here and who came to listen to me if I take a rather generous and hospitable and broad view as to the right of protest. It may come as a shock or surprise to some of you that I am of the view there are limitations to that right. And I would hazard that some of you will disagree with me upon almost everything, and some of you, or I think not so many, will disagree with me as to the limits to the right of protest. Certainly the right of protest includes not only the right to distribute a leaflet or to carry a placard, which are traditional and conventional forms of protest, or the right to engage in a parade. It includes the right to protest in new or different and unconventional and dramatic and arresting manner of protest. For instance, some years ago, when the United States was engaging in nuclear testing in the Pacific, a number of Quakers opposing nuclear detonation on the ground that it brought physical hazard upon the entire human race, bought a little boat and named it the Golden Rule, and undertook to sail the boat into the atomic testing area off the Marshall Islands. The Atomic Energy Commission had issued a regulation barring all persons from entering in that area. And so they determined to violate the law and to go into this area at the risk of their being blown to death. Now they did it because they felt first dangers of nuclear testing, They could do this much more dramatically and effectively than if they handed out a leaflet in front of the Atomic Energy Commission in Washington, D.C., and they were willing to pay with their lives for the exercise of this protest. And I defended their right, and I was in complete sympathy with their, on the one hand, violating a law, and on the other hand, engaging in this kind of a protest. Now, there are other examples of protests, which may or may not remind you of the manner of protest which has taken place on this campus. The suffragettes were a bothersome bunch of women. And they wanted the right to vote, and they meant to get it, and some of them thought it would be good, not necessarily good, but dramatic, if they chained themselves to the picket fence around the White House. Now, this is a violation of law. First place, the White House belongs to the president. Everybody knows that. And actually chaining oneself to public property, like the fence around the White House, is engaging in what is known as malicious mischief, which is a disorderly conduct. Anyway, they did it, and they got the right to vote. Now, Mahatma Gandhi had some ideas, and he encouraged certain practices. For instance, at one time, he urged his followers, in order to tie up the entire railroad system in India as a protest to British Empire rule, he urged his followers to lie down on the tracks. This would have meant that those who ran the trains would have had to run over and kill thousands and thousands of Indians. Those who ran the trains were also Indians, and they decided they weren't going to do that. But in any event, this was a violation of law, certainly a violation of British law. It was action rather than, it was conduct rather than merely speech or the distribution of a leaflet. And I would suppose that most persons are reasonably sympathetic to that kind of conduct, at least in India. Of course, it's easier to be sympathetic with actions somewhere else, with the struggle of the Negro in South Africa, for instance, or even in the South, than it is with the problems of the Negro in Watts or in Los Angeles, or problems around us. But in any event, I would suppose that upon reflection, you might agree with me that there are limits to the right of protest, particularly when it is in the form of conduct. Let me give you an example or two. There is in Puerto Rico a very strongly voiced, I don't know how strong, and militant nationalist movement which wants independence for Puerto Rico from the United States. And the leaders of the nationalist movement have for years attempted to appeal to the concerns or the conscience or the attention of all Americans. And so some years ago, perhaps you'll recall, a number of them went into the House of Representatives in the gallery in Washington, which they had a right to do. But they carried guns with them, and they decided that in order for them to be heard by Americans, they should shoot these guns in the House of Representatives. And they did. As a matter of fact, shot 2 congressmen. Well, there are some who say this isn't a great loss, but there's no point of being facetious about it. I would suppose that there are few civil libertarians who would say that a protest carried out in that manner is protected by the Constitution. In any event, if there are such civil libertarians, I am not among them, and I do not go that far. Now let me bring the problem, an example closer to home. I would suppose there are a number on this campus who vigorously disagree with the policies of the Chancellor. On the other hand, I wonder if it would, if it is if this kind of conduct is protected by the Bill of Rights, namely a group of students seriously opposing the policies of the Chancellor, deciding to go to his home, to secure ingress into his home by force or by guile, and engaging in a sit-in, in a lie-in, in a sleep-in, until the Chancellor capitulates to their demands and signs on the dotted line, turning over the control of the, turning over all of his power to the protesting group. Yes, there's going to be a short pause, not for a commercial, but I think they claim that my jiggling, the mic is going to be repaired, although I think it's working now. No? So relax for a moment and eat your TV. The personal reasons, you go wherever you need to go. Now we're back on fine, thank you. All right. Now I gave you an example of a sit-in which probably is not justifiable under any circumstance. On the other hand, in my view, many sit-ins are. And many sit-ins, or as they are commonly called, acts of civil disobedience, and I want to say a word about that before I'm done, of course, are not really acts of civil disobedience, but are entirely within the law. Let me give you some examples. In the South, restaurants discriminate against Negroes because of race. A group of persons, Negroes and white, go into a restaurant solely for the purpose of engaging in a sit-in as a protest to the policies of the restaurant. Now this, it is claimed, violates the rights of private property of the owner of the restaurant, interferes with the quietness and the enjoyment of food by the whites who come there not expecting any Negroes to be around, and it is claimed to be illegal as an interference with private property. And yet the courts have had little difficulty in ruling that such sit-ins, which are peaceful protests upon private property against the policies of the owner of that private property, such peaceful sit-ins are part of the right of protest guaranteed by the Constitution. What about a public library in the South, which has books only for whites and not for Negroes? And Negroes and whites who go to that library not to borrow a book, well, no point of Negroes going there to borrow a book, they were not allowed to borrow a book, but who upon asking for a book are told to get out, continue to remain to the annoyance of the librarian and the quiet whites who are sitting in meditation, contemplation, and reflection, reading Chaucer or Shakespeare or whatever, or the Bible, more probably the Bible. But in any event, that kind of a protest, though not the distribution of a leaflet in a public street, is protected by the Constitution. Now I've talked about disobedience then, because that sit-in the public library was a violation, so it was claimed until the matter reached the United States Supreme Court, of the rights of the library and the librarian not to have persons engaging in a sit-in who were persons who weren't there to read or meditate or contemplate. In any event, There, of course, have been numerous instances in current American history, and I think of one just at this moment. I think of my sitting in Washington before a United States Senate Inquisitorial Committee with Linus Pauling at my right. At that time, he had not yet won a Nobel Prize twice. He had only won a Nobel Prize once, and he had been subpoenaed to bring with him the records, including the names of those who had circulated a petition to be submitted to the United Nations seeking an agreement among the nations outlawing nuclear testing. He was asked for the names of those who distributed the petition. And he said to Senator Dodd, who sat up there with all the righteousness which unbecomes a corrupt politician, he said, "I will not answer that question. I have refused to comply with the subpoena. I have not brought the names of persons, and I will not give you the names of persons. And this I do on my conscience, and this I do because of the Constitution." And because he had won a Nobel Prize, the committee decided to let him go. But others who were not Nobel laureates, who took the same position, have been in penitentiaries throughout the country for engaging in what could be called civil disobedience, namely asserting conscience, asserting the Constitution above the commands of the Congress. Or take the First Unitarian Church of Los Angeles, confronted with a requirement that it take a loyalty oath as a condition of securing a tax exemption. It defied the tax assessor. It defied the voters of California who, by popular vote, through a large majority, enacted a provision in the California Constitution requiring all persons, including churches, to submit to a loyalty oath pertaining to their opinion and association in order to secure a tax exemption. To be sure, the position of the First Unitarian Church was ultimately vindicated because it had the money and the courage to go to the United States Supreme Court. Also had the help of the American Civil Liberties Union, and that sometimes does not hurt. Be that as it may, in the first instance, that church was defying constituted authority, was violating the Constitution of California and the law of California, did it because of its religious commitment and because of its commitment to conscience. And of course, Martin Luther King, who is the great protagonist of civil disobedience in our land today, has had to do what many of his predecessors similarly committed have had to do or have done. Has just recently served a 5-day jail sentence for violating the law, that is to say, violating an injunction of a court which prohibited a parade or a demonstration, with Martin Luther King insisting upon his right to participate in the parade as protected by the Constitution, and guessing wrong, because when his case reached the United States Supreme Court, Thurgood Marshall was not yet a member of it, and so he lost his case by a vote of 5-4, 5 against him, and he has given unto Caesar what Caesar demanded in his case, 5 days in jail. As a matter of fact, he served only 4. The authorities in the South were so anxious to get rid of him that they let him out of jail a day before just to make sure he wasn't around on the 5th day to be the beneficiary of a huge reception. Well, then, I've been talking about civil disobedience, and I have been saying that in many instances civil disobedience is fully protected by the law, and in some or many instances are beyond the pale of the law. I would say despite my fears that there may be many or some among you who would stoutly disagree, that the right of protest and the right of civil disobedience to be within the law and perhaps within the Constitution does not include the right physically to obstruct ingress and egress to some place which is ordinarily open to others. But whether civil disobedience is within the law and the Constitution on the one hand, or outside of it, I want to make this comment about it, though I claim no expertise and claim to be no authority on civil disobedience as such, for that is a complex philosophical and perhaps even religious problem which is beyond my ken. But I would characterize acts of civil disobedience as having to have all of the four following ingredients or essentials. First, that they are acts based upon conscience, acts which a person does, words which he utters, or acts which he commits, stemming from the source of one's entire being. I would suggest that they are acts which are non-violent, though there may be some argument as to what constitutes violence. I have not said that they are acts of non-force. I have said they are acts that are non-violent. A third essential, it seems to me, before an act can be an act of genuine civil disobedience, the person who commits the act must be ready and willing to pay the full price which society demands for his act. If it is a violation of law resulting in jail, the person who commits such an act, here I'm not talking as a lawyer, I'm talking as kind of a pseudo-philosopher, a quasi-philosopher, or would-be philosopher. The person must be ready to pay the price which Caesar exacts. And if the price is a fine, pay the fine. If the price is going to jail, to go to jail. And of course, when he's willing to pay that price, he's not alone in terms of history. Socrates was willing to pay up the price and paid it with his life for entertaining views which were ahead of his time, which were unacceptable to the powers that be and to the establishment. Martin Luther certainly expected to pay a price. And when he nailed his thesis on the church wall at Nuremberg, he said, "This I do, I can do no other." He had made his decision. He knew he'd have to pay for it, but he was ready to pay for it. So when persons who commit acts of civil disobedience come to me for legal help, I have a very dour look when the person who's involved cries about or is unwilling to pay the price which he must have known society would demand of him, more so than of anyone else, more so than of the petty violator of law. And Thoreau, who is the founder of civil disobedience, I would suppose, certainly was always willing to pay the price and insisted upon paying the price. He was opposed to taxes, and the tax collector didn't give a darn. But he went to the tax collector and reminded him that he hadn't paid his taxes and that the penalty for non-payment of taxes is a jail sentence. And the tax collector, confronted with the law, had to enforce it. And so Thoreau went to jail, as you know. And you know, of course, the famous exchange between Emerson and Thoreau. Emerson came to visit Thoreau and said, "Henry, what are you doing here?" You know what Thoreau said? He said to Emerson, "Henry, what are you doing out there?" And I've given you the example, I gave you the example of Martin Luther, and I've given you the example of Martin Luther King. Now, I think there's a fourth ingredient, an essential to civil disobedience, and here I'm way out of my experience, no, not experience, knowledge, no, not knowledge. Anyway, the fourth ingredient is love. And I preach it, but I don't claim to practice it. That means love for the fellow whom you ordinarily hate. Certainly for the fellow whose views you detest. It means love, for the American soldier who fights in a war that you disapprove. It means love for the administrator at a university, because that's easy for me. I don't have any problems with an administrator at university. But it means this attitude of somehow, when engaging in civil disobedience, well, let me put it this way, though I'm sure I didn't intend to say this. It seems to me when a person engages in civil disobedience throughout the ages, and in 1967 in Los Angeles, he expresses not only his own views, but he speaks for all of mankind. He speaks for the entire human race, past, present, and future. And when you're that kind of a spokesman, you have to speak with great dignity, and I think with what the Quakers call love. Well, so much for civil disobedience. What about civil disobedience, or not civil disobedience? What about the draft? Now, this is a matter of grave concern to the American Civil Liberties Union. It has been of such concern that the American Civil Liberties Union in 1917 was organized almost entirely originally in order to protect persons of conscience who were unwilling to submit to the draft. The first draft law was adopted in 1917 on the eve of the First World War. The first draft law had no recognition of conscience at all. Every person, male person, was subject to the draft, and hundreds of conscience objectors were drafted. There was no provision in the civil law for any redress. They were in the army. They were court-martialed. Some of them received 20 years in a military penitentiary simply for refusing to obey a military order because of conscience. Later, the Congress adopted a provision defining conscientious objectors. A provision very narrowly drawn so as in effect to bar all persons except those who were members of so-called accredited peace churches like the Quakers or the Mennonites. And one had to, in order to receive a classification as a conscientious objector, have a religious training and belief in a supreme being with a capital S and a capital B. Now there are many persons who are religious and who believe in a supreme being but not capitalized. And there are many others, more others, who are religious and who do not believe in a supreme being, whether the initials are capitalized or not, but whose conscience stems from broad considerations of humanity, and who are just as sincere and just as conscientious as those who are given to the literal reading of a page in the Bible, which of course qualifies man as a conscientious objector, where no one questions that. In any event, it is the position of the American Civil Liberties Union, and it is probably the law, that any person who is opposed to the draft and to war because of conscience, as distinguished from religious belief, is entitled to a classification as a conscientious objector. But probably one has to be opposed to not only war, but to all war. What about the fellow who is not opposed to all war, who believes in wars of independence or just wars, but who's opposed to the war in Vietnam as an unjust war or an unconstitutional war. Well, it is the view of the American Civil Liberties Union that any person who is conscientiously opposed to any war, including the war in Vietnam, though not necessarily opposed conscientiously to all wars, should be granted an exemption. But then there is the problem in connection with the war and in connection with the draft of persons who believe they have a right as a means of expressing their opposition to the war to burn their draft cards. Now, the position of the American Civil Liberties Union, to which I adhere, is that the act of Congress, which makes it a crime, a serious felony, to be visited upon persons for burning draft cards, is probably unconstitutional. And it is our view, though of course I hasten to make it clear, we do not encourage the burning of draft cards. We do not encourage the burning of anything. In fact, some of us are opposed to all burnings. I personally am opposed to the burning of books, for instance. But there are many who would say that the burning of a draft card is in a different category, and I'm not here to quarrel with that. But in any event, it is our position that one who burns a draft card as an act of protest ought not to go to the penitentiary simply for exercising the right to protest in this dramatic and, I was going to say, flamboyant or flaming manner. Well, now let me see. Actually, I was going to speak about some other things. But no one is a free human being, really. We are all captives of one sort or another, and I'm a captive of time. And it is now 10 minutes or so of 1. And I think what I should like to do is yield to the exigencies of time and discontinue this formal talk. You know, I'm kidding when I say formal. And discontinue my philosophic and other ruminations to which I have subjected you for almost an hour, so that there will be a short break, after which I am advised by the establishment. You have the right to ask questions, or I suppose even to make comments, and I have both the right, and I have the obligation, which I'd be glad to take on, and the right to retort. So, shall we take a break now? But as many of you as can remain are, of course, invited to remain. Is that right?
Right.
All right.
The break is mainly just so those of you who have to go to classes can leave the room, and then we can just carry on our questions and answers in a very orderly fashion. There are, as you may already have noticed, 2 microphones at the floor of the grand ballroom on both sides. If you have any questions, why don't you just step up to those microphones, and once the room clears a little bit, we'll proceed. Oh, it's right here. All right, why don't we begin right now, in fact? Yeah. Why don't we start with that The gentleman off to my left.
I understand now that in California, juveniles over the age of 18 can be tried as adults if so stated by a judge. And since this group is not able to vote for the assemblymen and congressmen who passed that law, I'm wondering if this statute would be considered unconstitutional.
Well, that's an interesting question and a kind of a novel one. Needless to say, my own view is that persons who are old enough to fight are old enough to vote and should be allowed to vote. I had a problem somewhat similar to that some years ago. During the Second World War, Americans of Japanese descent were put into concentration camps. And many of them refused to be drafted on the ground that since they had been robbed of all of their rights, they were in concentration camps, they had no obligations and weren't obligated to serve under the draft. We succeeded in convincing some of the judges about to that position, but not too many. I think we'd have a difficult time in the courts in an effort to persuade the courts that merely because certain persons weren't allowed to vote, persons say from 10 under, that legislation affecting them was unconstitutional. But the time ought to come, and real soon, when those at least of 18 should be allowed to vote. And someone talked to me about the matter this noon and suggested he'd like to be a guinea pig for a test case to challenge the constitutionality of the proscription against those over 18, those under 18 from voting, and we may take the case on. So ask me this question about a year from now, and I'll have a better legal answer for you. Yes.
Could you explain what the Constitution has to say about the rights of a person tried before a military tribunal to have his case go to the Supreme Court? There seems to be some doubt in my mind as to what's going on. These things have happened quite recently, several.
Yes. Generally, it is the position of the colonels in the Judge Advocate's Office of the United States Army and the Armed Forces that the military are a law unto themselves. And of course, this was a position they took, but ultimately not successfully, in connection with the declaration of martial law in the Hawaiian Islands during the Second World War, and in connection with the military evacuation of persons of Japanese descent from California and from the entire West Coast. Efforts have been made to secure review of actions of military tribunals in the higher appellate courts, and have thus far been unsuccessful because these efforts were launched before a person who had been convicted before a military tribunal had gone through the entire military procedure. There is a procedure whereby one who is convicted by a court-martial may appeal his case, the conviction, ultimately to the highest military tribunal, which, though part of the military establishment, consists entirely of civilians. From that decision, a case can go to the United States Supreme Court. So in actual fact, there is a provision for securing ultimate judicial review by civilian authority, but it's a long, long trip and an arduous one along the way. Yes, who's next? Yes.
Do you think the draft is a form of involuntary servitude and therefore unconstitutional?
I thought so from 1917 to 1920. At that time, shortly thereafter, the American Civil Liberties Union launched a challenge of that draft law. As a matter of fact, that challenge should have won more readily than a challenge now, because in 1917 we were not at war. We wouldn't go to war until 1920. And anyone who tells you that we're not at war in Vietnam is living in a dream world. But we'll pass that. In any event, the challenge of the draft law was made by the ACLU and was turned down by the courts. Frankly, we are not quite ready to make that challenge again at the present time. On the other hand, there are questions ancillary to the larger one, whether the draft law itself is constitutional, and that is whether or not the war in Vietnam and the drafting of soldiers to be sent to Vietnam are within the constitutional authority of the government. Within the ACLU, we are closely divided on that issue. A majority of the board of the ACLU in Southern California has just taken the view that sending soldiers to Vietnam against their will abridges their constitutional right, because we are engaged in a war in Vietnam, and the Constitution provides that in order for us constitutionally to be engaged in a war, the Congress should declare such war, and the Congress hasn't done it. In connection with the prosecution and the conviction of Captain Levy, there are some other questions, namely the legality of the conduct of officers and soldiers in Vietnam, and whether their conduct violates certain of the principles enunciated by the Nuremberg Tribunal, which condemned war criminals. These are matters which are in the process of clarification, and with respect to which we in the ACLU are not yet in entire agreement. Yes?
Mr. Wirin, you stated at the first of your talk that you wanted to comment or did have a statement or a belief of some sort on Mr. O'Leary. Now, this could tie in with my general question. I think we all agree to a certain degree that the state has a right to say something about what we do with our bodies, but does the state have a right to tell us to any degree what we should do to our bodies? For instance, the taking of drugs and so on and so forth.
Well, that's really put very well. It's put very well. Let me try to answer it. First, with respect to Timothy Leary, I think, to me, it's clear that the sentence which was imposed upon him for importing marijuana into the United States, a sentence of 30 years in a federal penitentiary, to use a phrase which I've been using the last month in the Los Angeles Superior Court, is cruel and unusual punishment, and is abominable and atrocious. Whether or not the use of marijuana as such should be made a crime is an open question in my mind, and certainly in the minds of many. Now, but the question, as you put it, is pretty broad. Should a person have the unlimited right to do what he wants to his body? Well, I suppose at first reaction and at first blush, one would say yes. On the other hand, if what one does to his body, and this is a ridiculous example, if one decides to inject into his body viruses or germs which are contagious, I suppose you'd agree. Of course, as I say, it's a stupid example because no one does that. Certainly, I would agree generally that what one does with his body or to his body should be his concern and not that of the state. I suppose I would go a step further and say that what adults, although the question is who's an adult, what adults do with their bodies should be their concern also. I'm thinking of sexual conduct, which is made seriously criminal. In England, sexual misconduct, if you want to call it that, between adult males in private is no longer a crime. So I think I would generally accept the premise or the statement which you made. There may be some exceptions. On the other hand, I'm taking too much time to answer this question. On the other hand, when you say what someone does to his body, mightn't the corollary question be, does he do it in private or in public? For instance, if one were to inject heroin into his system in public, I wonder if this doesn't raise if that isn't a matter in which the public has a concern so that it could make such conduct criminal. So having beat all around the bush, I think I'll rest with that elaborate and non-responsive answer.
Excuse me, Mr. Wirin, what would
Yes.
what would the basis be for saying that the public nonetheless has the right to say what he does with the body in public, merely because it's out in the open, he's doing it in the open?
No, I think the basis would be, let's take the case of heroin, that it would encourage others to take heroin. I think with respect to heroin, it's demonstrable that very serious harm can come first to the person who takes it, which from the point of view of your question is of no concern to anyone else, but harm to others who are even encouraged to make such use.
Might it not just have the opposite effect, however?
Well, could be, but I think our society is probably too primitive to recognize it.
Thank you.
Yes, sir.
What's your opinion on the legality and morality of the mill-in technique being used in Berkeley right now?
I didn't hear the question. Say it again.
What's your opinion on the legality and morality of the mill-in technique being used in Berkeley right now?
Now you see what you've done. You've asked me a question. You've exposed my ignorance. I expose it. What is that technique?
The mill-in being used in Berkeley right now.
The mill-in?
Right.
Oh, now I understand. I thought somehow I was still thinking of that other, of that question over there, and I thought it had some relationship between the two. All right. I assume the mill-in is a device of protest whereby persons express their opinion, and in doing so obstruct others.
Right.
Mm-hmm. Oh, I take the position, well, I take these positions. I think a mill-in, which results in actually obstructing others, is probably outside the law, probably illegal, and probably beyond the protection of the Constitution. I don't think a person who engages in a mill-in should get capital punishment. In fact, I don't think anyone should get capital punishment, so it certainly shouldn't apply to milliners. I think that's my answer to you. If one feels he has to engage in a mill-in as a matter of conscience, because that's the only effectual way of expressing his point of view, I think such a person should be prepared to go to jail. A campus jail, however, rather than an outside jail, I'd say. Yes, sir. Yes, sir.
Before I ask my question, I was wondering if you'd take a little stronger position on that last question about the legality of the draft. It seems to me that when the Constitution was written, they certainly planned on providing for the common defense, and although I'm strongly opposed to the draft personally, it seems to me that it must be legal.
There must be what?
It must be, the draft must be constitutional.
Why? Although I guess I'm not supposed to ask you any questions, but why?
That's okay. Because,
why?
I mean, first of all, I'd say the 13th Amendment was meant to apply to Negroes and other slave-type individuals, even if they were white slaves, and not the draft. And also, the constitutional provision for providing for the common defense would certainly imply the draft. So I don't see how there could even be a strong argument for the unconstitutionality of the draft.
Well, thank you for saying that, but not only do I think there's a strong argument, I believe in that argument, that the draft, the argument against the draft that is unconstitutional, well, if we're going to have a war, particularly a number of thousand miles away from our homeland, in another place, upon dubious invitation, why shouldn't those who want to fight the war go and fight it? Why should others who don't believe in that war, who think it's immoral, why shouldn't some Negroes who have much in common with Orientals racially, and who really prefer Orientals to whites, and I think I can understand why in many instances, why should persons be compelled by others, particularly when the Congress hasn't even declared that it wants it done in a formal declaration? Why should young people have to go against their will and first take the lives of others with whom they have no quarrel, and secondly risk their lives? I don't know. In a society which differs from those behind bamboo or iron curtains, which prides itself on the freedom of the individual, on the right of the individual to make decisions for himself as to what he shall do, what he shall say, and what he shall do, and what shall happen to him, why should a person be compelled to go and risk his life or take the lives of others? At least that's the argument. I think it has considerable merit.
All right. And the main question I wanted to ask you was if you would take a stand on what the possible constitutionality would be of some law prohibiting Dow from being on our campus.
A law prohibiting Dow? Well, you say a law, you mean a
Well, say
you mean a law by the chancellor, or a law by the legislature, or what?
Either. I suppose if there would be if Dow would be outlawed, I imagine it would be a rule by the chancellor. Would that be a legal rule?
Oh, I'm sure it would be. And I would suppose, if the time ever came to pass, and I hope it might be soon, when the administration of the campus would be, as I think it should be, through tripartite control, namely the administration, the faculty, and the students, I would think that a vote of such an institution or agency, that a particular person or institution not be allowed on the campus to recruit employees, I think would be perfectly proper.
And it wouldn't be a violation of free speech?
I would think so. I would think that a private employer has no constitutional right to come on the campus to recruit employees, or even to speak if he's not wanted to speak. If I wanted to speak here and nobody wanted to listen to me, but that's not really a good example, because I suppose there are many here who do want Dow on the campus.
Yes, but I mean, like if there was a rule saying we could have no right-wing speakers on campus.
Oh.
It seems
well,
to me
the Civil Liberties Union would be first to take that case to court if necessary, or to oppose such a rule. Because you see, then left-wing speakers like me would not be permitted also.
Right, and that's why I was thinking under that same kind of logic, that it's almost like discriminating to put Dow off. I mean, if you're going to eliminate Dow, you could eliminate left-wing speakers.
Well, you may have a point there. On the other hand, it seems to me there is a difference. First place, if a representative of Dow were invited to speak by a group of students, no matter how small, and were not allowed to speak about the merits of napalm, for instance, the ACLU would insist that this was a violation of freedom of speech. But I think there's a difference between someone being permitted to speak on the campus and someone occupying an office to recruit employees. I don't think the Civil Liberties Union has a constitutional right to have an office to recruit membership in the ACLU, though I guess I'd like it.
Thank you.
Yes, sir.
My question asks you to return to your position as would-be philosopher, as I think we all should try to be, and also returns to a comment that you made at the very first part of your speech and made glancing reference to in the answer to your last question, where you talked about your ideal of tripartite participation in the running of a university. It's a very attractive idea to believe that you have obtained what is best when you obtain participation in the running of an organization. But I think that's too facile an answer. I think it's very likely in the running of this campus were students to have a voice in any number of bodies, be it the placement center or the academic senate or a totally student-dominated student council, that the decisions that would be made by the method of including large or unanimous student participation wouldn't be very different than the decisions that are made by the non-students now in charge. So I ask is participation enough?
Well, I thought I was being radical in just suggesting participation, but in any event, certainly, if the thrust of the question is, or the import of the question is, that students ought to do more than participate through their governing bodies in important decisions on the campus, if the suggestion of the question is that students ought to have the sole decision, I'm sure I wouldn't agree with it, and in addition to that, it would of course be utterly unacceptable and impractical.
No, I don't think you gather my meaning.
Good. I mean bad. Go ahead.
I would think that we have to be concerned with the content of the decisions and not just in who makes them. Most of the students on the campus would make the same decisions that their elders would make. And I think that this would leave the minority of the students that are presently demonstrating still desirous of demonstrating.
Oh, all right. Well, now I understand the question better. Certainly, when I suggest participation by students in decision making, I did not intend to intimate that a majority of the students then speak for every student, and the individual student on the one hand, or a minority group of students on the other, have no rights. On the contrary, the whole genius of our Constitution, and I think the genius of an academic community, is the full protection of the right of the dissenter and the right of the individual and the right of the few, so that certain basic rights like freedom of speech and freedom of assembly, freedom of expression, and the right to protest within the limits which I've indicated must be accorded to all and to each, and must be accorded by the majority of the students to the minority of the students. Does that deal with the question you asked?
With your emphasis there, it seems to make the participation point irrelevant.
No, because it seems to me that there are points at which participation would be relevant and important. For instance, should the placement center, should the Dow Chemical Company have a place at the placement center? Now, it seems to me this is something that might be well be decided not by the administration alone, but by the administration and by the faculty and by students. Now, that's a decision. On the other hand, that doesn't mean that assuming the majority of assuming this tripartite institution decided that Dow should remain on the campus, as apparently the students have just decided for themselves in this referendum, that doesn't mean that the right to protest Dow should be denied to any individual student. On the contrary, that right obtains, and should obtain, and must obtain, if an institution is not to, if a university is not to become a concentration camp.
I have a
Yes, sir.
I have a two-part question.
Yes.
First of all, does the ACLU involve itself in legislative lobbying as well as court action? And second of all, I understand that the ACLU is now looking for membership and expanding its organization. Could you comment on the usefulness for students to participate in a local branch of the organization?
Yes. Well, in first place, while I'm a lawyer, and so my work is in the courts, except when I come down here or a place like this now and then. Most of the work of the Civil Liberties Union is conducted first by volunteer lawyers in the courts, and then a very large portion of the work is in the legislative halls, particularly in the legislature in Sacramento, as well as in Washington, where we have a full-time director. Now, what can the students do? Let me postpone answering that question until a little bit later, after I've answered these four, because I have on my note to say something which I neglected to say before, and I want to say it later. So I'll try to answer your question in a comment which I'll make before I'm done. Let's see, who's next? Yes, sir.
Yeah. Could you tell me if you think that Justice Trainor's decision in the Proposition 14 case makes much sense in terms of constitutional doctrine?
Well, as a matter of fact, Justice Traynor is Chief Justice, and he's a very great judge. And he did not write the decision in the Proposition 14 cases. Justice Peake did. And it was a very poor decision. But it was good enough to get 5 votes in the United States Supreme Court on our side, so it's good enough for me. Yes.
Mr. Wirin, I wanted to ask this one question while I remembered it. We know that the Attorney General annually, or wherever he does, comes out with his list of subversive organizations. Now, apart from the question whether the Attorney General himself is constitutional, which is a different question, do you think that he has the right to prohibit such organizations as the Abraham Lincoln Brigade, people who were communists 30 years ago, from, putting organizations like that on subversive organizations lists and things like this? Do you think, in other words, that the subversive organization list is constitutional?
Well, I think that question I can answer quickly, but answer it tangentially. Tom Clark, just retired as Justice of the Supreme Court, his son is Attorney General, was Attorney General of the United States and put into effect this subversive listing business when he was Attorney General. 3 or 4 years ago, as an act of public atonement, he admitted to two errors he made in his public life. He was talking only about his public life. And he said the first one was that he was participated in, and indeed he was largely responsible, for the decision of President Roosevelt to put Japanese into concentration camps. He said that was wrong. And the other thing that he did that was wrong was to set up the subversive list procedure. So I don't think there's any question of what the courts, certainly the court as presently constituted, with Thurgood Marshall, a staunch liberal, and substituting for Tom Clark, who neither staunch nor a liberal, or nor a liberal. Certainly the Attorney General's list is not only on its way out, but I think is now virtually a matter of the past. So I agree there shouldn't be such a list. Yes.
My understanding of Justice Black's position on the 14th Amendment is that he feels it includes Amendments 1 through 8 and nothing else, and that Justice Douglas feels that it includes more than 1 through 8, also Amendment 9. And I was wondering why Justice Black excludes Amendment 9.
Well, Justice Black is now over 80 years old. Why anyone does anything is a matter more often for a psychoanalyst to determine than certainly for me. And Justice Black is much too old for a psychoanalyst's couch.
Isn't Justice Black
in any event
most amenable to your views, though?
Well, that's a very interesting question, and I think we have a few minutes, and I have to tell you a story which is interesting to me. You can either stand or sit down as you prefer. Will you wait till I tell the story? About a year ago, I was one of the lawyers to argue Proposition 14 in the United States Supreme Court. And this is kind of a long story, but I'll try not to make it longer than necessary. As you know, Proposition 14 was adopted by the voters of California. It put into the California Constitution a provision legitimating racial discrimination in housing. And 4.5 million voters of California voted in its favor, with only 2.5 million against it, so it won 2-1. And then the case was filed in the California Supreme Court, and a question was just asked about that, and the California Supreme Court, in a vote of 5-2, said that the proposition was unconstitutional. Now, almost in every case that we are in the United States Supreme Court from Southern California, I have appealed the case to the United States Supreme Court. As to this case, this was the first time that I opposed an appeal to the United States Supreme Court because we had won it in the California Supreme Court. We didn't want any more appeals. We were quite satisfied. But the California Real Estate Association was not satisfied. And so they appealed the case to the United States Supreme Court. We opposed it. Usually the United States Supreme Court decides whether to hear a case in about a month. This appeal, the United States Supreme Court took about 6 months, and then decided to hear it. Now, we knew we were in a bad way. And of course, we had studied the decisions of the justices of the Supreme Court, and we had seen Justice Black, though a great libertarian on the issue of freedom of speech, freedom of the press, and the rights of the individual, something seems to have happened to him, I don't know what it is, so that he became very critical of the civil rights movement, generally. He became very, almost angry about sit-ins. He thought they violated private property. He thought demonstrations in the streets were wrong, that the place to get your rights is in court, through courts. And he had expressed this again and again, though usually still in dissent, because there were 5 votes without him, usually, in connection with the 14th Amendment and the application of the 14th Amendment to sit-ins and whatnot. And so the Supreme Court granted a hearing on Proposition 14 over our will, and I was arguing the case. And Justice Black was clearly against us in every major respect.
How about Douglas?
Douglas was for us in every major respect. And as I was arguing the case, Justice Douglas said to me, why don't you, what about this? Oh, I have to interrupt this story. Incidentally, I told you we won the case. We won the case because Thurgood Marshall, who was Solicitor General, appeared as a friend of the court on our side. And that's why we got 5 votes. But we'll pass that. I saw Mr. Marshall the day before and told him what my argument was going to be. And he said, for Christ's sake, don't make that argument. Because Black, if you make that argument, you and Black will be fighting all the time. You'll get nowhere. So I had determined to try to get Black and White. Ultimately, we got White, we lost Black. But I had determined to try to appear to talk to Black in order to pick up White's vote, who was a swing man, because it looked as if we had 4 votes, but we needed a 5th. So Douglas asked me a question, and I kind of shushed him away. I've known him for many years. He said, Mr. Wirin, I'm trying to help you. I said, I know you are, Justice Douglas. But you see, I'm trying to persuade Justice Black. And I said, this is the first time I've appeared in this court in 30 years when Justice Black and I have not seen eye to eye. And the other justices were a little concerned as to what Black was going to say in view of this confrontation. And I said to Justice, and you see what a difficult, to Douglas, to the court, you see what a difficult time I'm having in persuading Justice Black. And Black smiled then, and everything was friendly. And then even I was trying to tell Justice Douglas, for Christ's sakes, keep quiet. We know we have your vote. I'm not trying to get your vote. And if you put your finger, if you stick your nose in, you'll make it impossible for us to get White or Black, whose vote we desperately need. Now let me talk to these guys and see if I can't pick up one of them. You be quiet in the meantime. Of course, I didn't say that, but I almost said that. And Douglas kept quiet and let us deal with White. And finally, and of course Douglas we had anyway, and White came through in shining armor on a white horse. Now, have I answered your question? Or have I?
We answered most of it. Can you say something on the 9th Amendment?
On the what 9th Amendment? Oh, well, actually I am not too given to the 9th Amendment anyway. I think that any rights which the Supreme Court is willing to support, it can support through the 14th Amendment and support through the first 8 amendments. So I'm not too worried about the 9th Amendment, though I think it's a good amendment, and I'm glad it's in the Constitution. Okay. Yes.
Yes. Can you tell us what's the current state of the ACLU case, I believe filed on behalf of the Englewood doctor regarding against the Los Angeles Police Force and the city regarding suppression of his right to peacefully assemble June 23rd at Century City.
Yes. We have a number of cases in connection with with Century City, and the ACLU has sponsored a test case against the chief of police, seeking damages against him under the Federal Civil Rights Act on the ground that he abridged constitutional rights in making an order of dispersal which resulted in the injury of hundreds of persons in this community. And in connection with that question, and as a final comment to you, let me say this. I had intended to talk not merely about the Bill of Rights on the campus, but the Bill of Rights in the nation. But the Bill of Rights is a large subject, and the nation is a large place. And so let me just say this word. A student's rights on the campus a student's rights are important. They're important to the student. But they're more important than that. They're important to all of society, because the rights of students on the campus are inevitably and inextricably intertwined with the rights of all persons everywhere. Because students not only go to a university, they are also parts of the community. Take what happened on June 23rd. Students were as much the victims of police misconduct and police clubs as were persons who are not students. And so I was glad to come here to talk to you about the rights on the campus, because I wanted to say to you how important it is for you to be concerned about your rights while you're on the campus. Because if you begin to demonstrate that concern in your own rights while you're on the campus, you will exhibit that concern when you're off the campus and part of the community as a whole. And if you do that, you will be protecting the Constitution, not only your own rights, but the rights of others. You will be serving our society as a whole. You will be doing that which I've just urged unsuccessfully a court in Los Angeles to do in a capital punishment case, but which in a case which we hope to win in the higher courts. You will be serving the dignity of man. And to that commitment, protecting the Constitution and serving the dignity of man, both while you're on the campus and when you leave the campus, I have come here today to invite you to join the others in the Civil Liberties Union or elsewhere who are dedicated to protect rights under the Constitution and pay respect to the dignity of man. Thank you for asking me to come.
Mr. Wirin, on behalf of the students at UCLA and on behalf of the establishment, I might add, I want to thank you very much for coming.